Orders, item 11.
May it please, my lord.
Yes.
My lord, item 11, 12, and 13 are analogous, my lord. And the interlocutory application has been filed for condoning a few days, my lord. For the days are slightly different, my lord.
This
In
is
item 11, my lord, there's a delay of 406 days in filing the connected LA appeal number 1 of 2024, my lord.
This is by the state.
Yes, my lord.
You want to file an LA appeal.
Yes, my lord.
Okay.
We've already filed the appeal, my lord.
Who's for the other side?
For the other side.
Appeal is filed but not yet admitted.
Yes, my lord. Because the delay has to be considered, my lord.
In fact, in other places, it is not even registered.
Yes. Out it's already registered.
Out here, everything is registered.
Yes,
Other places, only the delay, when delay is condoned, then direction is given for registration of the appeal. Number is given, then matter is taken up. And how many respondents are there? 36.
Yes, my lord.
Any objection filed?
Yes, my lord. They've already filed their objection, my lord.
Okay. So what is your ground explanation
Yes, my lord.
for the delay?
Coming to page number 7 of the delay application, my lord.
Page number 7, yes.
Yes, my lord. Point number 2, my lord. Small Roman 1. This is when, my lord, the appellants first came to know about the impugned judgment and order, my lord.
What is the date of judgment?
The date of the judgment is 29/20/23, my lord.
29, 2023.
2023, my lord.
And your knowledge came?
Only on 6/6/2024, my lord.
How is that?
I have explained the reason out here, my lord. The reason for this is that, my lord, the project director, the project implementation unit ISOL, had received a letter from the superintending engineer, PWD chief engineer Rhodes, my lord, because of a letter received from the advocate of the claimants, my lord. It was only through this letter that they were aware of the judgment and order 29/2023, my lord. If I may kindly take your lordship to the letter that was sent to the project director, my lord. Annexure 1 is at page 18, my lord. Dated 6 June 2024, my lord. Addressed to the Director, Project Implementation Unit ISOL, subject LA case number 1 of 2015, 2 of 2015, and 3 of 2015.
Yes, I've read it.
Yes, my lord.
Come to the next page.
Yes, my lord.
This is by the counsel for the respondent.
Yes, my lord. This is the annexure of the letter, my lord.
Just read this. I'm forwarding herewith.
I am forwarding herewith a copy of judgment and order 29/2023 passed in LA case number 2 of 2023 for favor of information and necessary action, please. It may be noted that a copy of your esteemed office has been prepared by the Honorable Court. However, no affirmation action in compliance to the above judgment and order was performed by your esteemed office till date. Hence, with the thought that there is a great chance your office might not receive the above referred judgment and order, a copy of the same is forwarded to you for information and necessary action. It was the counsel for the petitioners who had notified the government, my lord, with regards to the presence of the judgment and order dated 29/2023. It was only through this letter that the concerned department was aware of the impugned judgment and order, my lord.
Okay, who is the Special Land Acquisition Officer? He's a departmental officer of the department,
Yes, my lord.
designated as the Special Land Acquisition Officer.
Yes, my lord.
What is his role?
His role is to assess and determine the amount of award to be made, my lord.
Special Land Acquisition Officer,
Yes, my lord.
PWD.
Yes, my lord.
Under what provision? This is land acquisition, isn't it?
Yes, my lord.
Under what provision?
It is under the 1894 Act, my lord. But, my lord, the on merits, my lord, the thing is that it was a consented award. Agreement was signed between the parties, and it was a consented award. However, after receiving the award, the petitioners had approached the court for reference, my lord. And everything else.
Consented award passed by whom?
Between the parties, the concerned landowners and the department, my lord.
Okay, they agreed to a certain amount.
And an agreement was signed and everything, my lord. Yes, they agreed to a certain amount.
Okay, that is one side. What about this Special Land Acquisition Officer?
He has been authorized under the 1894 Act, my lord,
To
to perform the duties of a collector, my lord.
what is he? He's in the rank of? Normally it's the deputy commissioner and the collector
Yes, my lord.
who is the land acquisition officer. Since when did the Public Works Department have their own land acquisition officer? Appeal is filed by whom? PWD.
Yes, my lord.
Then your own officer knows about this award.
No, my lord. The thing is,
He
after,
doesn't have
this-
to be reminded. He has passed the award.
after receiving the award, my lord, later they had approached the reference court.
Under what provision?
18, my lord.
How is it possible?
It was entertained.
Any agreed amount which is settled by the parties
Yes, my lord.
is an agreed amount.
Yes, my lord.
If it is an agreed an agreed amount, where is the question of going
Reference.
for enhancement through
Yes, my lord.
reference?
But it was enhanced. It was entertained by the reference court, man.
Okay.
That is our main grounds of appeal on merit, man. Because the apex court in several rulings has said there is no ground for reference when it's a consented award, my lord.
Okay, leaving aside that consented award, I'm not very satisfied about this Special Land Acquisition Officer. What is the order of reference in which he was appointed as Special Land Acquisition Officer?
If your lordship will,
And where is the consented award? Is it a part of the records?
it's a part of the records in the appeal. man.
Let us see. Page number.
Page 33, Annexure 5, my lord.
See the top line.
Under Rule 13 of Mizoram Land Acquisition Rules 2011, signed by both parties.
What is that rules? What is that Land Acquisition Act which was set aside by the single judge and affirmed by the DB? That was the Mizoram Land Acquisition
The 2016.
16.
Yes, man.
So what is this 2011?
This was a bit,
Rules enacted under what provision? It's just one-page agreement.
And the actual pay receipt is on the next page, my lord. Along with the signature of payee, my lord. It's not, the whole has been annexed, my lord. All the agreements of the landowners, my lord.
Agreement is signed separately by each of the landholders.
Yes, my lord.
This is one such agreement only,
Yes, my
is
lord.
it?
Yes, my lord. With regards to the Special Land Acquisition Officer, my lord, there was a notification issued on 13 August 2013, which is at page 25, annexure 1, my lord.
What is this?
This
Section
is the
4.
notification.
This is a Section 4 notification.
Yes, my lord. Out here at point number 2, my lord, it has been stated that any person interested in any land being notified may submit his or her objection to the acquisition in writing to the Special Land Acquisition Officer, Project Implementation Unit, PWD, within a period of 30 days from the date of publication of this notification in the Mizoram Gazette, who will dispose of the objection and claims as per provision of Section 5A of the Land Acquisition Act 1894, my lord.
5A. You have the LA Act with you. Five A subsection 2 says every objection under subsection 1 shall be made to the collector
Yes, my lord.
in writing, and the collector shall give the objector opportunity of being heard, and so, and after hearing the objection, after making such further inquiry, to the appropriate government. Containing his recommendations on the objection together with the record of the petition. For the decision of that government, the decision of the government on the objection shall be final. So after this Section 4 notification, what happened?
There was another notification dated 30th August 2013, which is at page 26, annexure 2, my lord.
Next page only.
Yes, my lord.
This is regarding
The rate of compensation and replacement of value of lands, structure, crops, and other properties, my lord.
then next is the
Meeting minutes, my lord.
meeting minutes. They determine the value of the thing. land, trees, crops, and structures.
Yes, my lord. Even in the meeting at the attendance sheet, my lord, the representative of all the landowners was also present, my lord.
Who is that? Serial number?
5, my lord. Page 28, serial number 5, my lord.
Then what is page 29?
29 is another meeting minutes, my lord. Dated 12/11/2013.
The same date.
Yes, my lord.
So what is the difference between these two meetings on the same date? One was at 9:30 a.m., one is 1 p.m.
Yes, my lord.
First half, second half.
At towards the bottom, my lord, at point number 3, that was inserted 3 and 4. The area between the fish pond and garbage disposal area may be fixed at rupees 30 per square feet. And the area between garbage disposal area up to Molkoi village may be fixed at rupees 10 per square feet, my lord. That was also added, and again in the attendance sheet, my lord, there was a representative of the landowners was present
Then again, page 31.
at serial number 5.
This is only attendance.
Yes, my lord.
It's not that by marking yourself to be present, does it mean that you agree to what have been resolved?
The agreement will come when they had consented and signed the agreement, my lord.
So although it started off with a notification under Section 4 of the LA Act 1894,
Yes, my lord.
ultimately there was some sort of a negotiation or some agreement meeting and all that, and then ultimately there was an agreement. Some rate was fixed in the meeting,
Yes, my lord.
then ultimately an agreement was signed,
Yes, my
and
lord.
they have received the amount.
And they've received the amount without any.
And when did they file the 18th reference? Agreement is signed when? 5/9/24.
Yes, my lord.
All of them? No. 29/4/24.
5/9.
2014. Not 24, 2014.
Yes, my lord.
So basically, it's in the month of September of 2014. Such agreement has been signed. And payment receipt is also there. This also is marked as September 2014.
Yes, my lord.
Then when did it go for reference? How was it referred? Who referred? Is it highlighted in the impugned judgment? Section 16.
Yes, my lord.
It was not 18, 16. If you see the impugned judgment, the first paragraph.
Yes, my lord.
What is section 16? Power to take possession. When the collector has made an award under section 11, he may take possession of the land which shall thereupon absolutely vest in the government, free from all encumbrance. Power to take possession. Section 16.
Yes, my lord.
Now you come to the impugned judgment. It says, being dissatisfied with the preliminary award, present 37 petitioners file application under section 16
Yes, my lord.
of the LA Act praying for direction against the Special Land Acquisition Officer to take fresh measurement and to pay land value at the rate of rupees 200.
Plus 30% solation from the market value.
That is not the provision in section 16. Is there some typo error?
This is the copy of the impugned judgment and order that was applied for and received, my lord.
Certified copy.
Yes, my lord.
It is not just a copy, it's a certified copy.
Certified copy, my lord.
It says section 16.
Yes, my lord.
Reference comes under 18.
Yes, my lord. And moreover, another point, my lord, is that the landowners had asked for the land value at 200 per square feet, my lord. This was the amount that was given at Mui Sairang area, my lord.
What did you say?
My lord, the land value rate that the landowners had claimed for, my lord, was as per the rate that was given in Mui Sairang area, in that railway case, my lord.
Uh-huh.
And the same was applied, and hence even in a place like Lunglei Tlabung, the same 200 was given, my lord, without taking into consideration the prevailing market value as per the 1894 Act.
In which case?
In this case, my lord.
Okay, then why did you why did you not immediately take steps? Only when some letter came from the lawyer,
Yes, my lord.
which was forwarded to the respondent on 6/6/24,
Yes, my lord.
you woke up suddenly.
Because the government advocate who was at Sampai, my lord, had made no communication. And I had not specifically mentioned that his
No.
service was even terminated, my lord.
No.
Because he gave
may
no
not, he may
copies.
not have communicated to you, but why did you keep quiet about it? You come to page number, or you come to paragraph number 3 of the impugned judgment. Just read.
Pursuant to the notice of the Honorable Court, the respondent opposite party submitted written objection on 20th November 2015, wherein they stated that the measurement of the land to be acquired were taken carefully with an instrument called total station, which is the most accurate instrument for taking measurement of land in Mizoram, and the areas so derived with the instrument were exactly with the road design, and the total station is the instrument used for taking measurement of the petitioner's lands while processing their land. They further stated that before fixing the rate of land, a special committee constituted by the government of Mizoram to determine the replacement of land, structure and crops for the project affected villages held its meeting on dated 12/11/2015 at the residence of Pusi Lalde and Azautlang. The committee consisted of representatives of PIU, Public Works Department, village council members, landowners, non-governmental organizations, minor irrigation department and agriculture department, and discussed on the fixed rate sufficient to
Okay,
compensate. Yes.
okay, Mr. Samuel, you can
Yes.
pause there for a moment. So what I was trying to show you is that pursuant to the notice issued by the court, parties submitted the written objection on 20th November 2015. Now, do you mean to say your appointed counsel, on his own, he submitted his WO?
No, my lord. What I'm trying to
So
Yes,
that means you know what is happening. You instructed your counsel to file WO, he filed it. Later on, in order to substantiate, petitioner examined his witness.
Yes,
And the judgment says you have also cross-examined. So thereby it goes to show that you were aware about the pendency of this reference. How can you say that suddenly on 6/6/2024 you came to know about this judgment out of the blues?
No, my lord. They knew about the existence of the reference application. A
Right.
government advocate was present. But what happened during the proceedings after the judgment, the impugned judgment and order was passed, my lord? There was no communication made to the department with regards to the judgment and order.
Right.
Yes, my lord.
Do you
So
have
they
to
were
just-
not aware.
So that's why the department, does he have to be just remain silent all along after engaging one counsel? He will look after everything. You don't even bother to ask what has happened to that reference, anything. What steps have you taken after you received this on 6/6/2015? 24.
After it was communicated,
Did you ask your counsel? Why did you not inform us about this judgment? Have you asked?
they had sent 5-6 letters to him. Not even just the PWD, even the Law and Judicial had sent him a letter.
When? Where's the letter? Show me. It's unbecoming of an advocate. He's engaged by his client to do something.
Yes, my lord. The
He
first
has to
letter
inform.
would be at page 20, annexure 3 of the IA, my lord.
Page
20, my lord.
20.
Annexure 3. No, apologies, my lord. This is not the first letter. It's page 21, my lord. Annexure 4.
21. Yes.
If I may read, my lord, it's a small paragraph, my lord.
Read.
With reference to the subject mentioned above, I have the honor to state that this office has not received any official letter from the court nor your office regarding the judgment and order dated 29/2023 in connection with LA case number 1, 2, and 3 of 2015, passed by the Additional District and Sessions Judge, Champhai District. It may also be mentioned that all the related documents submitted to the court is needed for counter appeal against the judgment and order passed by the Additional District and Sessions Judge, Champhai District, to the Honorable High Court. In view of the above, I therefore would like to request you to send all the documents related to ALA case number 1, 2, and 3 of 2015 to the undersigned at the earliest. This was the letter, my lord. And a reminder was sent again on 22nd October 2024, which is at page 22, annexure 5, my lord, which is just the next page, my lord. If I may read, my lord.
No, don't require. I've read it.
Yes, my lord.
Then, after that, what happened?
Then after that, the department had received an execution case number order dated 25/10/2024, my lord.
That page?
Page 23, annexure 6, my lord.
This is received by the department.
Yes, my lord.
Now, whether your letter you have sent to your counsel was received by him, did he reply?
Yes, my lord, it was received.
How do you say that?
Before that, my lord, if I may take your lordship to page 29, annexure 9, my lord. This was another letter sent to the government advocate by the Undersecretary, Law and Judicial Department, dated 30th October 2024.
Saying what? Once again.
Yes,
Once
my lord.
again.
Out here, all the earlier letters were even highlighted, my lord, again, wherein he was asked to provide all the related documents.
So the project director sought the assistance of the law department. We have written 2 letters, nothing is happening. You please write 1 letter
Yeah,
from our
because-
side.
Yes, my lord.
Did
Because,
he reply?
no, my lord, that is the problem.
Then
He had never.
Is he still your counsel?
No more. His service has been terminated because of this, my lord.
It is true that a considerable amount of trust and, so to say, entrustment of the case is given to your appointed counsel.
Yes, my lord. It was his
But
duty.
at the same time, it is also the duty of the client
Yes, my lord.
or the person who takes the service of that counsel to also be vigilant.
Yes, my
You
lord.
have to ask what has happened to that case. Because earlier notice was there, you filed WS. When evidence was led, he cross-examined.
Yes, and
So you
informed
cannot
them
just sit in the office and wait for all time to come and say that nothing will happen. He is there. He'll look after everything. Suddenly on 6/6/24, you get a letter. Then you wake up. Oh, this has happened. Then you start writing letters. And see, information came to you, like you said, on 6/6/2024 for the first time.
Yes, my lord.
And you write your letter when? In September. You came to know about this in June, but you write in September. July, August, September, 3 months. You were trying to understand what is written in the letter or in the order for 3 months until you decided to write to your counsel. How do you connect that? 6/6/24 and 2/9/2024. In between, what is the explanation? You have filed the application. Just show me what is the statement.
Yes, my lord. The first annexure, my lord. This was the letter, as earlier mentioned, my lord, 6 June 2024. And annexing the letter that was issued by the counsel for the petitioners with regards to the existence of the impugned judgment and order, my lord. Then thereafter, on 7 August 2024, my lord, page number 19, my lord. This was a letter issued by the Engineer-in-Chief PWD addressed to the Joint Secretary, my lord, dated 7th August 2024. Subject LA case number 1 of 2015, 2 of 2015, and 3 of 2015. With reference to the subject mentioned above, I have the honor to state that this office has received a copy of letter from Pulalbi Agnungan Namte, counsel for the petitioners regarding the judgment and order dated 29/23 in connection with LA 1, 2, and 3 of 2015 passed by Additional District and Sessions Judge Champai on 29/2023, which was ruled in favor of the petitioners. Mention may be made that PIU PWD haven't received any official letter regarding this matter from the government advocate nor the Champai District Court till date. But the project implementation unit PWD Mizoram is aggrieved by the judgment passed by the Additional District and Sessions Judge Champai. The aforesaid case is therefore proposed to put forward before the Honorable High Court for counter appeal against the judgment against the order passed by the Additional District and Sessions Judge. After this, my lord, a letter...
No,
Yes.
just pause there for a moment. Letter which you just read is dated 7th August
Yes, my lord.
24.
Yes, my lord.
Information given to the project director was on 6 June. And there's a round seal in which it's clearly
Yes, 6/6/24, man.
seen that he has received that on the same day, 6/6/24.
Yes, my lord.
Then why did he write a letter on 7th August? June, July, August, after 2 months. What was happening in 2 months? How do we connect that? You come to your statements in paragraph, page number 7,
Yes, my lord.
paragraph 2, subpara 1. Project director received a letter. Thereafter, at paragraph 2, you say,
At paragraph 2, I have stated, my lord, the date from the impugned judgment and order till 6/6/2024, my lord. 8 months and 16 days had passed, my lord, altogether.
no, that's okay.
It's a date of 258 days, my lord, as per my calculation.
No, thing is that what kind of steps have you taken? That's what I want to know. The explanation is important. Number of days doesn't matter.
Yes, my lord.
You should have a proper explanation. That's all. See, come to paragraph number 2. It says, a letter for filing appeal against judgment and so-and-so was sent to the Joint Secretary. When? On 7/8/2024.
Yes, my lord.
This is what you just read.
Yes, my lord.
So 6 June to 7th August, nothing happened. 6 June to 6 August, nothing happened. But on 7th August, he writes a letter
Yes, my lord.
after 2 months. What is the period of limitation for filing an appeal?
90 days, my lord.
90 days. So more than 50%, 60 days he has spent doing nothing. When the appeal has to be filed within 90 days,
Now, my lord, the
from the directorate, or you can say the chief engineer's office to the government, it takes 60 days to receive one letter.
yes,
How
my
do you
lord.
explain that?
My lord, the thing is, they were aware of the judgment, the impugned judgment and order, but they had not received any copy, not from the court, nor from the concerned government advocate, my lord. So,
what stops you to detail an officer or a person to go to Champai and get the copy yourself? Keep on writing letter like that. Letter goes, he receives, doesn't reply. Then you send a reminder, nothing happens. Then you write to the law department, please write one letter for us. Nobody bothers going to Champai. You could have gone there, send one person,
yes, my
go and
lord,
pick up the entire file and come back.
it's a collective responsibility of the government advocate to inform the department as well, my lord. Because unless and until these copies are provided by the government advocate, they will not be aware of the existence of the judgment and order, my lord.
No, but you are aware now.
Yes, my lord.
The opposite party's counsel has written a letter enclosing a copy of the judgment. So by 6/6/24, you already know that there's a judgment which has held that you have to pay something more. But then you don't do anything. Maybe you made verbal inquiry, verbal request here and there. But to see what you have done, letter is available only after 60 days. Then, please go on. After that, what happened?
After that, my lord, a letter dated 23rd August 2024, my lord, was sent by the Under Secretary PWD to the Advocate General, my lord.
What will he do? You don't have a judgment, you don't have the
That
pleadings, nothing
yes,
is
my
there.
lord.
No written objection.
Yes, my lord. In the second paragraph, my lord, they have stated that the project implementing unit PWD Mizoram is aggrieved by the judgment passed by the additional district session judge, Champai district. The aforesaid case is therefore proposed for counter appeal against the order passed by additional district and session judge Champai before the Honorable Guwahati High Court. In this connection, I am directed to request you to take necessary action for your end, from your end. Now, my lord, out here, no copies of the judgment and order was available and nothing was furnished, my lord. Then after this,
No, it's available. See the letter, the bottom, list of documents enclosed. Grounds for preferring appeal, number 1. Number 2, copy of the order. Order was there.
order, at this stage, the order might be there, not the certified copy for preferring an appeal.
No problem. You file without certified copy, no problem. You just have to make one sentence
Yes, my lord.
that the appellant craves leave of the court
To produce the...
to allow the filing this appeal without a certified copy, but the appellant undertakes to file a certified copy as and when the same is procured, so that delay doesn't happen.
Yes, my lord.
If you add that sentence, you can file it. Court may or may not accept it. If court doesn't accept it, it's different thing.
It's usually not accepted, my lord, without
But
certified copy.
unless you file, how do you know that court is not accepting it? It is not your case that court has not accepted it. It is your case that we did not have a certified copy, so we did not file appeal. And plus, we could not contact our advocate. Then,
Thereafter, my lord, all these communications letters were sent to the government advocate
I
asking
think
him
your
to...
friend is noting down the points.
He has all the copies. my
And every step I'm giving you some question and he's noting down the
lord.
points.
Yes, my lord.
Okay, then, AG was written, informed, then what happened?
Then, my lord, we require all the witness statements, evidence that was taken, my lord, in order to file the appeal, and hence the department and asked the government advocate, my lord, to furnish all the documents, my lord. This was the letter sent on 2nd September 2024, my lord. By the project director, project implementing unit PWD, my lord. And thereafter, another letter was sent on 22nd October 2024, my lord, by the project director, again to the government advocate Sampai, my lord, requesting him to send all the related documents, my lord. And since nothing was coming forth, my lord, the petitioner had filed the execution case and a copy of the same was received by the concerned department, my lord. And the date of the order was 25/10/2024, my lord.
Then what happened to the execution case? The execution case?
The execution case is still there, my lord, but
Still pending?
still pending, my lord.
What is this, page 34? What is enclosed in this letter? It's not there next to your application.
This would be the execution case number 3 of 2015, as the subject has specifically highlighted, my lord.
Subject is execution case.
Yes,
It
madam.
says, I'm directed to forward herewith a copy of the ID number so-and-so of the Law Department, I guess, with its enclosures received from the Under Secretary Law Department,
Yes,
which
ma'am.
is self-explanatory. So what is the annex there? We don't know. You have not annexed it.
Yes, my lord. I have not been furnished a copy of the same one.
Then you should ask. What is the then purpose of annexing this document then? If you don't understand what is enclosed in that. I hope you understand what I'm saying.
Yes, my lord.
There is no explanation. It just says there's an enclosed letter. Please look at it. It is self-explanatory. And there's nothing to look at it also. So ultimately, how many days delay?
406 days, my lord.
4 and 6 days.
Yes, my lord.
So your main ground for explanation is that you were not informed by your lawyer
Yes, my lord. And that
and
the
delayed receipt of the certified copy and all those materials.
yes, my lord.
Then ultimately, when did you receive it? And how long did it take for you to draft it?
At page 13, my lord. Roman 11, my lord. The copy of the certified copy was issued, and on the same date it was given to us, my lord. Because of the urgency, my lord.
Within 1 day, you got it.
Yes, my lord.
Things which you could not get for the last 3-4 months, you could get it 1 day.
Because there was already
So where there is a will, there is a way.
there was already
You had no will to get the copy earlier. Simply writing one letter after 2 months.
because in order to file the appeal immediately, my lord, considerable days had passed already, my lord.
No, did you have to wait for the certified copy to start drafting the appeal?
It's because we had to look at all the evidences that were taken and given, my lord.
No, certified copy.
Yes, my lord.
Certified copy of what? Judgment and order, isn't it?
Judgment and order, along with all the related documents in order to finalize the LA appeal, my lord.
But that you have not stated anywhere. Paragraph 11, which you just read yourself.
Yes, my lord.
Impugned judgment was furnished on 5/11/24.
Yes, my lord.
Thereafter, counsel for the applicant started drafting. You don't require a certified copy to draft an appeal. You can draft in advance. Only when you file, you have to enclose that certified copy original. That's all.
Yes, my lord. But as per my understanding, on earlier occasions also, when we do not provide a certified copy, sometimes it gets rejected, my lord, from the registry, causing further delay, my lord.
You have not understood what I'm saying.
Yes, my lord.
The registry part comes later on.
Yes, my lord.
I'm talking about your drafting.
Yes, my lord.
The government advocate drafting the appeal. You don't require the original certified copy to start drafting. With a Xerox copy, photocopy, you can start drafting. Only when you go to file in the registry, that time you should have a certified copy at hand, enclosing in the appeal.
Yes, my lord.
Correct?
But we had to look at all the other related documents that were available in the this thing, my lord, as per the reference code documents, because our grounds of appeal, we had to be sure, my lord.
That is your submission.
Yes, my lord.
It is not in your pleadings anywhere saying that we had received all the other documents, written objection, evidences, including the certified copy, then we could start drafting. You have not stated that. You have just stated that after receiving the certified copy, then we could start drafting.
Yes, my lord.
You cannot go beyond that. That's what you have stated. In other words, your submission is beyond your pleadings.
At point number 12, my lord, I've stated, my lord. However, on perusal of the reasons for the delay, the department asked to produce additional documents along with documents for filing the condemnation of.
No, this is additional grounds. That's
Yes,
all.
yes,
The materials were already there with you.
Yes, my lord. Because there was already a delay, my lord. In order to condone a delay of such days, my lord, all the documents had to be provided to us, my lord.
Correct.
Yes.
That is only on the technical point.
Yes, my lord.
Your appeal will be on merit. The appeal cannot be on technical thing. Technical means on the delay part.
Yes, my lord.
Regarding delay, you do not have proper materials, so you ask for additional documents. But insofar as the appeal is concerned, appeal grounds are different.
My lord, as your lordship is aware, out here, my lord, whenever we file an appeal, and if there's a delay, IA along with the appeal is filed, my lord, all together. Like earlier, your lordship had stated, in other places, it's not. Only once if the delay is condoned, then the appeal will be filed. My lord, out here we file it together, my lord.
No, appeal is filed.
Yes, my lord.
I did not say that appeal is not filed. I'm saying that appeal is not registered. It is not registered and numbered.
Yes, my lord.
It's just lying in the registry. Only the delay condonation will be registered as IAC number so and so. If delay is condoned, then court will say register it. Even if the court doesn't say register it, they will register it. And they will list in another day for admission,
Yes,
to admit or not to admit the appeal, like that. So what I'm saying here is that you already had the certified copy, you already had a copy of the order as on 6/6/2024. You did not have to wait for certified copy to start drafting it. You could have started drafting it at any point of time. And if you say that additional documents were necessary to draft the appeal, you have not said so in your pleadings. Nowhere have you stated that we had to wait for everything to start. So the explanation's rather sketchy, I should say. Then additional grounds for what? Additional grounds for condonation of delay, not for appeal. It is for delay.
Yes, my lord, because we had to gather all the documents with regards to the communication made.
What about the other cases? Like this only?
Yes, my lord, it's similar.
Judgments are of different dates.
It's all the same, my lord.
Same date.
Yes, my lord.
It's not a common judgment, right? It's a separate judgment of the same date.
Separate judgment, my lord. Separate, my lord.
Separate judgment. Okay.
Here, hold on.
Yes, what else do you want to submit? So that is the reason why you have filed this appeal after 406 days delay.
Yes, my lord.
What does the registry say as per their computation? Is it the same? They say 407. You say 406.
Yes, my lord.
No, this is what I had asked the registry to do at earlier point of time.
Yes, my lord.
Because learned counsels will file saying 100 days delay and registry will accept, okay, 100 days. But when the court calculates, it happens that it's 110 days delay.
Different.
So that's why, in order to be sure what is the actual date delay, you should calculate. Now they have done this. In the first page of the note sheet itself, it says, although you say it's 406, according to the registry's calculation, it's 407. 1 day more. Anyway, whatever it may be, this is your explanation.
Yes, my lord.
Correct. Anything else you want to submit?
If your lordship will allow me to place reliance on a few certain
Lipokau.
and many other recent ones, my lord. Lipokau, your lordship, I will not bother you with that. You are aware of.
No, you should, whatever you have come with, you can take it out, no problem.
The first one is, my lord, if I may start with the Lipokau itself. 2005.
Now, have you given the list of books?
I've given it all, my lord.
So you start citing it, you'll give me one by one.
2005,
Let us not
3
waste time.
SEC.
Yes. Which paragraph?
8 to 12 and 16, my lord. Page 757, my lord. If I may read, my lord.
Yes.
The proof of sufficient cause is a condition precedent for exercise of the extraordinary restriction vested in the court. What counts is not the length of the delay, but the sufficiency of the cause, and the shortness of the delay is one of the circumstances to be taken into account in using the discretion. In N. Balakrishnan and M. Krishnamurthy, it was held by this court that Section 5 is to be construed liberally so as to do substantial justice to the parties. The provision contemplates that the court has to go in the position of the person concerned and to find out if the delay can be said to have resulted from the cause but he had adduced, and whether the cause can be recorded in the peculiar circumstances of the case as sufficient. Although no special indulgence can be shown to the government, which in similar circumstances is not shown to an individual suitor, one cannot but take a practical view of the working of the government without being unduly indulgent to the slow motion of its wheels. What constitutes sufficient cause cannot be laid down by hard and fast rules. In New India Insurance Co. Limited and Shanti Mishra, this court held that discretion given by Section 5 should not be defined or crystallized so as to convert a discretionary matter into a rigid rule of law. The expression sufficient cause should receive a liberal construction In Breach, Indra Singh and Kanshi Ram, it was observed that true guide for a court to exercise the discretion under Section 5 is whether the appellant acted with reasonable diligence in prosecuting the appeal. In Shakuntala Devi Jain and Kuntal Kumari, a bench of 3 judges has held that unless one of bona fides of such inaction or negligence as would deprive a party of the protector of Section 5 is proved, the application must not be thrown out or any delay cannot be refused to be condoned. In Concord of India Insurance Co. Limited and Nirmala Devi, which is a case of negligence on the counsel which misled a litigation into delay pursuit of his remedy, the default in delay was condoned. In Lala Matadin and Narayan, this court had held that there is no general proposition that mistake of counsel by itself is always sufficient for condonation of delay. It is always a question whether the mistake was bona fide or was merely a device to cover an ulterior purpose. In that case, it was held that the mistake committed by the counsel was bona fide and it was not tainted by any mala fide motive. At paragraph number 12, my lord, the next page. In OP Katpalia and Lakhmir Singh, a bench of 3 judges has held that if the refusal to condone the delay results in grave miscarriage of justice, it would be a ground to condone the delay. Delay was accordingly condoned. In Collector Land Acquisition and Katiji, a bench of 2 judges considered the question of limitation in an appeal filed by the state and held that the Section 5 was enacted in order to enable the court to do substantial justice to the parties by disposing of matters on merit. The expression sufficient cause is adequately elastic to enable the court to apply the law in a meaningful manner which subserves the ends of justice. That being the life purpose for the existence of the institution of courts, it is common knowledge that this court has been making a justifiable liberal approach in matters instituted in this court, but the message does not appear to have percolated down to all the other courts in the hierarchy. This court reiterated that the expression every day's delay must be explained does not mean that a pandemic approach should be made. The doctrine must be applied in a rational, common sense, pragmatic manner when substantial justice and technical considerations are pitted against each other. Cause of substantial justice deserves to be preferred for the other side cannot claim to have vested right in the injustice being done because of non-deliberate delay. There is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. A litigation does not stand to benefit by resorting to delay. In fact, he runs a serious risk. Judiciary is not respected on account of its powers to legalize injustice on technical grounds, but because it is capable of removing injustice and is accepted to do so. Making a justice-oriented approach from this perspective, there was sufficient cause for condoning the delay in the institution of the appeal. The fact that it was the state which was seeking condonation and not a private party was altogether irrelevant. The doctrine of equality before law demands that all litigants, including the state is a litigant, are accorded the same treatment and the law is administered in an even-handed manner. This is no warrant for according a stepmotherly treatment when the state is the applicant. The delay was accordingly condoned.
Any other paragraph?
16, man. It's a short one.
It's okay, I've read it.
Okay, man.
But do you know how many days delay was there in Lipogao? How much was the delay?
If
57 days.
57 days.
Yours is how much?
406.
Next case.
2014 1 SCC 592.
Para?
8, my lord. 8 and 9. Page 595, my lord.
Yes.
This was before para 8, my lord. It is correct that the condonation of delay cannot be a matter of course. It is also correct that in seeking such condonation, the state cannot claim any preferential or special treatment. However, in a situation where there has been no gross negligence or deliberate inaction or lack of bona fides, this court has always taken a broad and liberal view so as to advance substantial justice instead of terminating a proceeding on a technical ground like limitation. Unless the explanation furnished for the delay is wholly acceptable, or if no explanation whatsoever is offered, or if the delay is inordinate and the third party's rights has become embedded during the interim, the court should lean in favor of condonation. Our observation in Postmaster General and Living Media India Limited and Amalendu Kumar Bera and State of West Bengal do not strike any discordant note and have to be understood in the context of facts of the respective case. And the paragraph number 9, my lord, which is at page 596. In the present case, the High Court seems to have accepted the explanation for delay up to 2/11/2016, thereafter taking into account the statement made in the condonation application that the appeal has been filed on 2/11/2006, whereas it was actually filed on 8/11/2006. The High Court refused to condone the delay of the period between the two dates. Regarding the relevant paragraph of the condonation application, it is obvious to us that there is an apparent error or mix-up in the dates furnished by the state in its application for condonation of delay. The mention of the date in paragraph 5 of the condonation application is here by hand. Obviously, it is an error occasioned by the inadvertence. The date that should have been mentioned is 8/11/2016 and not 2/11/2006. The inadvertence, or even if the above act is construed to be negligent, in our considered view, cannot be sufficient to justify a refusal of the adjudication of the appeal filed by the state on merit, which is the ultimate consequence of the impugned order. Taking into account the totality of the facts of the case, particularly the period of the delay, we are of the view that in the present case, the High Court should have condoned the delay. The same not having been done were deemed inappropriate to allow the appeal and set aside the order dated 12/11/2008 passed by the division bench of the High Court, condoned the delay that had occurred in filing DB special appeal number so and so, and remit the matter back to the High Court for disposal on merits. We make it clear that we have not expressed any opinion on the merits of the case of the parties before us. This is another one.
Yes. Any other case?
Yes, my lord. 2023 10 SCC 531, my lord.
Para? What is the relevant paragraph?
17, my lord. Page 537, my lord. In this two, 17 and 18, my lord, it relates to the Lipok Owl. 18, my lord. And the paragraph 17 relates to the Katiji, which was earlier read out by me, my lord.
Yes. So no need to read.
My lord, at page 31, my lord. It's a short one, my lord. Para 31, page 541, my lord.
Yes. Read.
Sometimes due to want of sufficient cause being shown or an acceptable explanation being proffered, delay of the shortest range may not be condoned, whereas in certain other cases, delay of long periods can be condoned if the explanation is satisfactory and acceptable. Of course, the courts must distinguish between an explanation and an excuse. An explanation is designed to give someone all of the facts that lay out the cause for something. It helps clarify the circumstances of a particular event and allow the person to point out that something that has happened is not his fault. If it is really not his fault, Care must, however, be taken to distinguish an explanation and from an excuse. Although people tend to see explanation and an excuse as the same thing and struggle to find out the difference between the two, there is a distinction which, though fine, is real. Now, my lord, at page 544, my lord, para 40.
40.
Yes, my lord.
Yes, read.
We can also profitably refer to Koting Lamkang, cited by Mr. Sen, whereas the same bench of the three honorable judges of this court, which decided University of Delhi, was of the view that the impersonal nature of the state's functioning should be given due regard, while ensuring that individual defaults are not nitpicked at the cost of collective interest. The relevant paragraphs read as follows. But while concluding as above, it was necessary for the court to also be conscious of the bureaucratic delay and the slow pace in reaching a government decision and the routine way of deciding whether the state should prefer an appeal against a judgment adverse to it. Even while observing that the law of limitation would harshly affect the party, the court felt that the delay in the appeal filed by this should not be condoned. Regard should be had in similar such circumstances to the impersonal nature of the government's functioning, where individual officers may fail to act responsibility. This in turn would result in injustice to the institutional interest of the state. If the appeal filed by the state are lost for individual default, those who are at fault will not usually be individually affected. Having bestowed serious consideration to the rival contentions, we feel that the High Court's decision to condone the delay on account of the first respondent's inability to present the appeal within time, for the reasons assigned therein, does not suffer from any error warranting interference, as the aforementioned judgments have shown. Such an exercise of discretion does, at times, call for a liberal and justice-oriented approach by the courts, where certain leeway could be provided to the state. The hidden forces that are at work in preventing an appeal by the state being presented within the prescribed period of limitation, so as not to allow a higher court to pronounce upon the legality and validity of an order of a lower court and thereby secure unholy gains, can hardly be ignored. Impediments in the work of the grand scheme of government functions have to be removed by taking a pragmatic view on the balance of the competing interests. If your lordship will allow me to rely on only one more, my lord.
Why not? You have relied 3. What difference does it make? One more.
The last one is
Yes.
2024 15 SCC 1, my lord.
Para?
49, my lord.
Yes.
This is a judgment delivered by Justice Surya Kant Bala. Para 49, my lord. Nevertheless, the courts have been cognizant of the fact that as a custodian of public interest, the affairs of the state are run and controlled by human beings. Various factors, including the bona fide formation of erroneous opinion, negligence, lack of inactive, lack of fortitude, collusion or connivance, red tapeism, blurred legal advice, etc., sway the action or inaction of these functionaries, while waiving the public interest vis-a-vis an individual's interest who claims to have meanwhile acquired a vested right on the expiry of the limitation period. The court invariably tilt towards the public interest, keeping in view the irreversible loss likely to be suffered by the public at large, even in the case of private litigants where the appellate court finds that the opposite party can be suitably compensated with cost measures. A lenient and liberal approach is followed in terms of condonation of delay. Now at para 57 and 58, my lord, page 22.
This particular word waiving, You just read waiving.
Yes, my lord.
I think it should have been weighing. Weighing.
Yes, weight, my lord.
Weigh.
Yes, my lord.
To measure the weight or to. But it's written waiving.
Yes, my lord.
Waving is not the correct word, I think. Some
Must be
might have
some
been a mistake. Anyway,
typographical mistake, my lord.
so paragraph
57 and 58, my lord. Page 22.
57, 58. Yes.
We therefore find it a fit case to invoke the extraordinary powers held by this court under Article 142 of the Constitution. It is well settled that Article 142 empowers this court to pass an order in the larger interest of the administration of justice and preventing manifest injustice. This is most so in case involving protracted litigation and delay, such as in the present case. It is a matter of common knowledge that the case entailing discord over pay parity are frequently subjected to prolonged litigation. These squabbles often lead to parties enduring sufficient challenges and hardship over extended period as they await adjudication. Regrettably, the delay in resolving such matter usually renders them infructuous by the time a decision is reached. Thus, in light of the long pending litigation between the parties, the rights of the parties involved, and to give quietus to the issue, we deem it appropriate to pass order towards doing substantial justice, my lord.
This was regarding pay parity.
Yes, my lord.
And what was the delay? How many days delay?
Kapak orang di sini. $428 days, my lord.
Where do you find that?
Page 3, my lord. Towards the bottom, man. Page 3, man. So the citations I've relied upon, my lord.
Yes.
And that as per the IA application, my lord. We have not been sitting on the matter, my lord. In fact, we were trying to gather all the related documents, and which was the incorporation, my lord, of the so then government advocate who had not furnished anything on time, my lord. And that, if I may humbly submit that the reasons or delay are not unintentional, my lord. Unintentional, my lord, my reasons.
Okay.
And there is no negligence on our part in pursuing the matter, my lord. Obliged, my lord.
Yes, Mr. Biagnuar.
Please, Your Lordship, my lord, firstly, I'd like to submit that with regard to the Annex 1 of the IA, the date for the letter is dated 24th May, my lord, 24th May 24. And the applicant claiming that they have only the knowledge of 6.6 is highly questionable, my lord. Only on 6.6, and this would be 24.5, my lord. And my lord, at the left hand side bottom, my lord, is the letter dated 24th May. At page 18, my lord. Yes, left side bottom. Left bottom corner, my lord. Dated Aizawl 24th May 24. This is the letter. At page 18 of IA, my lord. Yes, Annex 1. Yes.
What is that date which you are talking about? It's not available here.
At the bottom, my lord.
The date of the letter is 6/6/2024.
No, my lord.
Come, show him this. Come.
This is not there.
I'm sorry, my lord. There is no page 18 in my petition, so the 18A, it is 18A. In my copy.
You don't have page 18?
Yes, in my
How?
copy.
How come is that?
It's right after the affidavit is 18A in my copy. 18A, the bottom left corner is,
24th May.
yes, 24th May. And my lord, after that,
No, you want to show me this letter,
yes, I have sent my letter on 24th May.
24th May.
Yes, and from New Capital to Equal Atlantic is only 5-minute drive, my lord.
No, but the letter sent by the superintending engineer to the project director on 6/6.
This letter was forwarded to,
And if you say 24/5 is the date on which they know, where is the proof? Seal and receipt of this 24 May 2024. This is simply your letter.
yes, my lord.
Now, if you come to page 18, you don't have page 18.
Yes, my lord.
Out there, there's a round seal. without seal, receipt number 439, date 6/6/24. This is entered in the register whenever you serve such kind of letters. Any correspondences? In the office, there's a person who receives the communications. He will put the seal, enter in the register, and give a number.
Yes.
So, in respect of your letter at page 18A, where is the acknowledgement of receipt? It is not there.
Not there, my lord.
So you say that it's only 2 hours drive. He will say that maybe 2 hours drive, but we have not received it.
Yes, yes.
So that kind of argument cannot go on in a writ court.
And
So best thing is that you could have obtained an acknowledgement in a seal. Somebody put down in writing that we have received it. Then that would have clinched the matter. Then next,
the next is that, my lord, if I take your lordship to the annexer 2, the next page, my lord.
yes,
The letter dated 7th August 2024. At the list of documents and clauses, number 1, the grounds for preferring appeal along with its enclosures. And number 2 is the copy of order dated 29/20/23. And my lord, the applicant has stated that they need the certified copy and its relating documents for filing an appeal.
yes,
Here, it is already stated in the letter dated 7/8/2024 that they already have the required document, my lord. The grounds for appeal is there, and its enclosure is also there. So, the applicant's statement that they need the certified copy of the JNO and all the evidences is not well founded, my lord. It is just a casual explanation. From 7th August 2024 itself, they could have prepared their appeal. That is what I am saying.
but this letter doesn't say that evidence is given.
But the grounds for appeal along with the annexes, its enclosures.
What is
already
that in
given.
a closure? Okay.
And in the next annexer T, my lord, 23rd August also, it is the same. The grounds for preferring appeal along with its enclosure was given to the Advocate General, my lord. From 23rd August itself, they could have prepared their appeal, my lord. So their casual explanation could not be accepted at this stage, my lord. And my lord, from 6/6 again, from 6/6 to 7/8, it is 62 days, my lord. The applicant is silent without having any explanation. They stated that they've received the copy of judgment and order on 6/6/2024, my lord. And only they have taken any action from 7th August 2024 only, my lord. That is after 62 days, my lord. So they are simply silent for 2 months and 2 days. And my lord,
And
the applicants put their blame on the one council at Champai, their council at Champai, madam. There is what I'd like to submit is that the applicants have the knowledge at the time of argument and they are present at the time of judgment also, my lord.
at the time of judgment also.
Yes, my lord.
How do you know? How do you say that?
No, their counsel is present, my lord. And there is not only one advocate at Champai, my lord.
Now,
There
how
is-
do you say that he was present on that day?
Judgment was pronounced in presence of both parties, my lord.
both parties means they were represented by their counsel.
Yes, my lord.
Supposing their counsel did not bother to inform them, then what will happen? He keep the news to himself and he doesn't want to inform the other side or his clients. Then, can you blame them?
No, my lord, no.
Then,
I'm not, it's not, I'm saying that, but what I'm trying to say is that there is not only one advocate, government advocate in Champhai, my lord.
So-
even if one advocate is giving them a problem in handing out in giving them the required documents, my lord, they can always approach another advocate, my lord. They can always inform another advocate to procure all the necessary documents.
definitely. I also told him that they can even send somebody from here to get the copies.
Yes, my lord.
So,
So that is not that explanation could not be accepted, my lord. And my lord, the explanation even in para 11, my lord, is that they have that on 5/11/2024, my lord, they have received a certified copy, and after that they have took 2 weeks to draft the appeal, and thereafter they informed they stated that on perusal of the reasons for delay, the department were asked to produce additional grounds along with documents for filing application for condonation of delay, my lord. Here, there is no documents to show that they have seek such documents, my lord.
their letter is not enclosed.
Yes, my lord. And this is just a casual explanation.
It's only a statement.
Yes, only a statement, my lord. And after that, they simply state that at para 13, sub-para 13, the council took another 3 weeks time to finalize the appeal, my lord. So, again, from 23rd of August, the counsel for the applicant had the knowledge the documents required for filing an appeal. They are already provided the grounds for appeal along with its enclosures. As per the letter dated 23rd August 2024, madam. So, taking another 5 weeks times to file an appeal, my lord, after receiving the certified true copy of the judgment and order, is not a good explanation for
5 weeks time
yes.
from 23rd August.
No, 5 weeks time from 5/11/2024, my lord. As per their sub-para 12. Para
Okay,
2.
5/11.
Yes,
Certified copy.
yes.
Appeal was filed on when? On 30th January.
31.
31.
This is all the explanations given by the state respondents could be, the state applicant could be adjudicated if they have put their hearts into this instant appeal, my lord. It could be done after their only 1 or 2 weeks after the receipt of the letter on 6/6/2024, my lord.
Okay.
So their casual explanation needs not be entertained, and the instant delay needs to be dismissed, madam.
Delay is to be dismissed or the appeal is to be dismissed?
The appeal
Application.
application needs to be dismissed, madam.
I'll take 5 minutes break and come back. And meantime, keep your answers ready
Yes,
to
madam.
this question.
Yes, madam.
Keep your answer ready to this question. The question is, judgment and order was passed by the LA judge, correct? LA judge on 29/2023.
23.
To 29/2023.
Yes, madam.
Why did you write your letter on 24 May 2024 after 6 months? I'm coming back.
due to bureaucratic movement of files, my lord.
Yes.
And my lord, at para 10 of my objection, my lord, I've stated here that there is from 5/11 to 27/1/25 and provide no explanation as to what transpired during this period of 59 days, my lord.
Paragraph 10.
Yes, as I've said earlier, my lord, after no proper explanation was given for 5 whole weeks, my lord.
According to you, how many days delay?
There's a typographical error, my lord. At page 15, this should be 406 days, my lord. And we have right at 433 days, my lord.
Paragraph 12. You've written 433.
Yes, yes. 13, para 13.
Paragraph 14 also, 433.
Yes.
Everywhere, 433. It should be
406 days, my lord.
406 doesn't look like this. Why did you write 433? Mistake can happen in one line, but it happens time and again. You have a different way of calculating. You said 403. How much?
406.
406. Okay.
No different dates, my lord. The and my lord, I have cited.
Yes, what are they?
Number one is the decision made by a coordinate bench in IA Civil number 169 of 2024, my lord. From para 10, my lord. It is seen that though the learned counsel has put the blame on his previous counsel for the delay of 311 days in filing the connected appeal against order dated 23/8/2023 in civil suit number 25 of 2016. However, there is no mention of the name of the previous counsel, nor are there any documents showing the same. It is, however, seen that in the order sheet of the learned trial court that learned trial court has observed in its order dated 15/5/2024, learned counsel for the plaintiff had submitted that he had handed over the files to the plaintiff and that he did not know whether he would be still representing the plaintiff. This is in contradiction with the reason given for delay by the applicant, wherein he had stated that he had got to know about the impugned order only on 30/5/2024, and that the said previous counsel had handed over the files to the applicant only in the month of August 2024. It is seen that in the apex court in Pundik Jalam Patil, Supra, held at para 12 as follows. In our considered opinion, incorrect statement made in application seeking condonation of delay itself is sufficient to reject the application without any further inquiry as to whether the affirmance made in the application reveal sufficient cause to condone the delay, and that a party taking a false stand to get rid of the bar of limitation should not be encouraged to get any premium on the falsehood on its part by condoning the delay. My lord, the reason for this is that, as I've said earlier, they have, the applicants have knowledge of, have the knowledge of the grounds for appeal along with enclosures, as I've said earlier. From 23rd August, the applicant's advocate have all the grounds of appeal along with its enclosures.
Okay.
That is why I've,
In this case, there was something regarding contradiction.
yes.
What was the contradiction?
Contradiction was, in this particular case, the contradiction was that the fault was due to the previous council.
No name has been given, isn't it?
Yes, yes.
Then, the other one. It is, however, seen in the order sheet of the learned trial court that the learned trial court had observed in its order dated so-and-so that the learned trial counsel for the plaintiff had submitted that he had handed over all the files to the plaintiff and he did not know whether he could still be representing plaintiff. So this is a contradiction.
But yes, here, in this case, is that even though the applicant here claimed that he has no knowledge, and
No.
fault of,
See, blame was put on the previous counsel.
yes,
But in the note sheet or in the order sheet, it was seen that the plaintiff had stated before the court that he had handed over all the
files to
Files
his
to
new
the
counsel.
client.
Yes,
to the new counsel or to the client.
to the
To
client,
the
my lord,
plaintiff, to the client.
plaintiff.
So there was a contradiction.
Yes,
So the statement was found to be incorrect.
yes, yes,
So the judgment of Pundik Jalam Patil was also referred to.
yes.
Then duty of the applicant to be more vigilant and all that. This is what I had already also indicated last time,
Yes.
some time back.
And also, my lord,
So you have placed this judgment or this order to support your statements or submission that in the debtor dated August something,
yes,
already enclosed, it was already enclosed with the
necessary annexes.
necessary documents and
Yes,
grounds of appeal.
yes, my lord.
Okay.
And the next one is that 2012 SEC online GAU 813. This is W. Rabi Singh versus State of Manipur and others.
Paragraph?
The para 8, my lord.
8.
Yes. There is no general principle saving the party from all mistakes of its counsels. If there is negligence, deliberate or gross inaction or lack of bona fide on the part of the party or its counsels, there is no reason why the opposite side should be exposed to time bar appeal, my lord. And 9 is that, para 9, my lord. From reading the application of the applicant appellant, it appears to us that the plea of negligence of the engaged counsel is taken only to cover up his own lapses with an attempt to save the limitation. And the next is 2012 to Supreme 244, Office of Chief Postmaster General and others versus Living Media India Limited and another. At para 13, man. Page 13, para 13. In our view, it is the right time to inform all the
Just a minute, just a minute.
Yes.
Paragraph?
12 and 13, my lord.
Yes, you may read.
From para 12, my lord. It is not in the dispute that the persons concerned were well aware or conversant with the issue involved, including the prescribed period of limitations for taking up the matter by way of filing a special leave petition in this court. They cannot claim that they have a separate period of limitation when the department was possessed with competent persons familiar with court proceedings. In the absence of plausible and acceptable explanation, we are posing a question why the delay is to be condoned mechanically merely because the government or the wing of government is a party before us. Though we are conscious of the fact that in matter of condonation of delay, when there was no gross negligence or deliberate inaction or lack of bona fide or liberal concessions has to be adopted to advance substantial justice, we are of view that in the facts and circumstances, the department can take advantage of various earlier decisions. The claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. And at para 13, in our view, it is the right time to inform all the government bodies, their agencies and instrumentalities that unless they have reasonable and acceptable explanation for the delay, and there was bona fide effort, there is no need to accept the usual explanation that the files was kept pending for several months, years, due to considerable degree of procedural red tapes in the process. The government departments are under special obligations to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government departments. Law shelters everyone under the same light and should not be sought for the benefits of the few. Considering the facts, there was no proper explanation offered by the department for delay except mentioning various dates. According to us, the department has miserably failed to give any acceptable and cogent reasons sufficient to condone such a huge delay. Accordingly, the appeals are liable to be dismissed on the grounds of delay. And the next is
How many citations do you have?
only one more.
One more.
Yes.
Okay.
JT 2008-11 SC 596, Pundik Jalam Patil, represented by legal representatives versus executive engineer, Jalgaon Medium Project and others, my lord.
Paragraph?
Paragraph 25 only, my lord.
Yes.
It is true, when the state and its instrumentalities are the applicants seeking condonation of delay, they may be entitled to certain amounts of latitude, but the law of limitation is same for citizens and for governmental authorities. Limitation Act does not provide for different period to the government in filing appeals or applications as such. It would be different matter where the government makes out a case where public interest was shown to have suffered owing to the act of fraud or collusion on part of its officers or agents, where the officers were clearly at the cross purpose with it. In a given case, if any such facts are pleaded or provided, they cannot be excluded from consideration, and those factors may go into judicial verdict. In the present case, no such facts are pleaded, and no proof, though a feeble attempt by the Land Council for the respondents was made to suggest collisions and fraud, but without any basis. We cannot entertain the submissions made across the bar without there being any proper foundation in the pleadings, madam. And the next is, yes. That is.
Yes.
My lord, to conclude, my lord, even though the applicants has stated that they have received their certified true copy only on 5/11/2024, and appeal was ready to be filed on 30/11/2025. They have the requisite documents necessary for filing, as I've submitted earlier, on 27 August 2024. That is my main submission, my lord.
All right. In your application, did you mention anything about the merit?
Not yet, my lord.
Not.
We have a good case on merit because it's a well settled law, my lord, that once the right of a landholder to obtain an order of reference would only arise when he has not accepted the award, my lord. This is a case where all agreements were signed.
No, that's why my question to you was,
Yes, my lord.
have you said anything in your application on that count? If they have accepted the award, why should they prefer the reference?
Yes, my lord.
The very fact of preferring reference means they did not accept the award.
At page 14, point number 4, my lord, I've stated that the
We have a good case, that's all.
yes, my lord, on merits, my lord, and prayed for grant leave to the applicant to rely upon the grounds set forth, my lord, in the
You have not
appeal.
elaborated or substantiated that. You say
For
that
the
I've got
purpose
good on
of
the merit.
considering the,
Obviously, you'll say that only.
yes, my lord.
Otherwise, what is the fun of filing an application for condonation of delay and the appeal itself, just for filing an appeal? According to you, you have some good case, good grounds, that's why you file appeal.
Yes, my lord.
But what exactly is that good grounds, you have not spelled out anywhere.
That we have
is the only
incorporated in
thing.
the main appeal, my lord.
Now, what about the other cases?
The days of delays are slightly different.
Different. But judgment is passed by the same court?
Same court, my lord.
Same court.
Yes, my lord.
And it pertains to different landowners.
Different landowners, my lord.
Okay. So, should we hear you on those other cases also? Because if they are all similar, then
My colleagues would like to place reliance on a few citations, my lord.
in which case?
In item 12 and 13, my lord.
No, before the citation, you have to tell us the facts. What is there?
Facts are all similar, my lord.
Facts are all similar.
Yes.
Yes, call item 12.
12.
Item 12. Who is the conducting counsel? Caroline.
Lordship, yes, my lord.
And the next case will be Ms. Lalun Louis.
Yes, my lord. It's analogous with the previous application. However, I have been endorsed to this case on 27/1/2025, and it took me 3 weeks and 1 day to file this application along with the appeal.
Okay. Give me the file. Your explanation starts from?
My grounds of delay starts from page 7.
Page 7.
Yes, my lord.
What is the date of the appeal? I mean, date of the impugned judgment?
Impugned judgment 29/2023.
Okay. Then, when did you know about the judgment?
Came to know about the judgment on 6/6/2024. It's all similar, my lord, the grounds
Okay.
of appeal, except on page 16.
16.
Yes, my lord.
What is there which is not similar?
In the fifth para, I have stated that I have been endorsed to this to file an appeal against LA number 2 of 2015 on 27/1/2025, and it took me 3 weeks and 1 day to complete and finalize the drafting.
Paragraphs 5.
The fifth para, my lord, page 16, the fifth line.
No, fifth line of page 16, which one? Paragraph? Give me the paragraph number.
It's just up to paragraph number 3.
What do you mean?
It is page 15, point number 13.
Yes.
Yes, my lord.
Then continuation of this paragraph number 13 is at page 16. So which part?
The fifth line.
Thereafter I have been endorsed.
Yes, my lord.
It took me 3 weeks. Everyone took 3 weeks time. You also took 3 weeks time
Yes,
to
my
draft.
lord.
So what is the difference? All right. And anything else?
I would like to produce one citation, my lord.
Yes, what is that?
2010 6 SCC 786.
Two thousand
2010 6 SCC 786. Para 16.
read.
While considering the application for condonation of delay, no straitjacket formula is prescribed to come to the conclusion if sufficient and good grounds have been made
Just
out.
a minute, just a minute. You said paragraph 16.
Yes, my lord.
What is that printout you have?
SCC online.
Because
Page.
out here I have only paragraph 15. Nothing beyond that.
It's Improvement Trust Ludhiana versus Ujagar Singh and others.
Name of party?
Improvement Trust Ludhiana versus Ujagar Singh and others.
Array, this is different. This is General Insurance Council and others was State of Andhra Pradesh and others. Citation is 2010.
Yes, my lord. 2010 6
6
SCC 786.
786. You're giving me 768. Okay. Paragraph 16, all right.
Yes, my lord.
In fact, there are so many paragraphs. Yes, 16.
Para 16 and 19.
Please read.
While considering the application for condonation of delay, no straitjacket formula is prescribed to come to the conclusion if sufficient and good grounds have been made out or not. Each case have to be weighed from its facts and the circumstances in which the party acts and behaves. From the conduct, behavior, and attitude of the appellant, it cannot be said that it had been absolutely callous and negligent in prosecuting the matter. And paragraph number 19.
Yes.
In our opinion, the ends of justice would be met by setting aside the impugned orders, and the matter is remitted to the executing court to consider and dispose of the appellant's objections filed under Order 21, Rule 90, CPC on merits and in accordance with law at an early date. It is pertinent to point out that unless malefites are writ large on the conduct of the party, generally as a normal rule, delay should be condoned. In the legal arena, an attempt should always be made to allow the matter to be contested on merits rather than to throw it out on such technicalities.
That's all?
Yes, my lord. May it please your lordship, I'm the Answering respondent in LA 3 2025, Your
Give
Lordship.
me item 13.
Your Lordship, the reasons for delay are similar. However, I would just like to present only one case law, Your Lordship, if I may be allowed.
Before we go to your citation,
Yes, Your Lordship.
what is the judgment?
The judgment is the same, Your Lordship.
Huh?
The impugned judgment or dated 29/2023.
Date is same.
Yes, Your Lordship. If I may be also allowed to give a short timeline that I have made, Your Lordship.
Sorry?
I have made a short timeline, if required. A short timeline of the dates, Your Lordship, and
List
the
of
events.
dates?
Yes, Your Lordship,
Huh?
if required. Your Lordship, the reasons for delay are the same.
6.
Yes, Your Lordship.
So what is different here?
Your Lordship, the only difference here is on on the last date, Your Lordship, on the 27/1/2025, the case was endorsed to me, and after which, Your Lordship, between 27/1/2025 to 24/2/2025, additional documents were sought, and also legible documents were also sought, and also, Your Lordship, if I may be allowed to admit that all of the seeking of the documents due to paucity of time was done verbally on call with the dealing assistant in the PWD office, Your Lordship. And also, Your Lordship, there was a slight delay in producing the legible documents because the department officials were also dealing with the village council election at the time, Your Lordship. And this has also been represented in my condemnation for delay on page number 14, paragraph number 13, Your Lordship.
See,
That is the only difference.
consideration of the court will not be restricted only from the time the file was endorsed to you.
Yes, Your Lordship.
It dates back from day one.
Yes, Your Lordship.
So you don't take things personally.
Yes, Your Lordship.
It's the entire thing is the respondent concerned.
Yes, Your Lordship.
What steps did they take, including their respective councils?
Yes, Your Lordship.
So that's what we have to see.
Yes, Your Lordship. Your
Period
Lordship.
of limitation is 90 days.
Yes, Your Lordship.
After deducting 90 days, beyond that, what did you do? That we have to consider.
Yes, Your Lordship.
What is the additional citation you want to?
Yes, Your Lordship, this is pertaining to when the High Court of Delhi had condoned a delay of 479 days. So, Your Lordship, this appeal was against that condemnation by the High Court. Now, Your Lordship, if I may be allowed to take Your Lordship to page number 6, Your Lordship, page number 11. This is slightly similar to the present case at hand. Page number 6, Your Lordship, page number 11. Mr. Sen was heard informing us of the negligent conduct of counsel for the first respondent before the reference court, costing him his impanelment. The delay in applying for the certified copy of the order of the reference court, according to him, was mainly due to the unprofessional conduct of the concerned counsel, and so implored Mr. Sen that such conduct should not have any bearing in mind of the court to nip a meritorious claim of the first respondent in the bud, particularly when stakes are high and the public exchequer is likely to be unnecessarily drained if the impugned order was interdicted. Now, Your Lordship, if I may take you to the last page, Your Lordship, that is page number 20, which is the observation of the Honorable Supreme Court, Your Lordship. Page number 20, paragraph number 37, Your Lordship. Your Lordship, if I may be allowed to read.
Yes.
Having bestowed the serious consideration to the rival contentions, we feel that the High Court's decision to condone the delay on account of the first respondent's inability to present the appeal within time for the reasons assigned therein does not suffer from any warranting interference. As for the aforementioned judgment have shown, such an exercise of discretion does at all times call for a liberal and justice-oriented approach by the courts, where certain leeway could be provided to the state.
the hidden forces that are at work in preventing an appeal by the state being presented within the prescribed period of limitation so as to not allow a higher court to pronounce upon the legality and validity of an order of a lower court and thereby secure unholy gains can hardly be ignored. Impediments in the working of the grand scheme of governmental functions have to be removed by taking a pragmatic view on balancing of the competing interests. For the foregoing reasons and the special circumstances obtaining here that the impugned order reasonably condones the delay caused in presenting the appeal by the first respondent before the High Court, the present appeal is accordingly dismissed pending application of any stands disposed of. Your Lordship, this is my only submission.
This was referred to by Mr. Samuel also, this judgment.
Shioraj, this is Your Lordship, Shioraj through legal representatives versus Union of India. This is 2023 INSC 885, Your Lordship.
Because the wordings at paragraph 37 seems to be quite familiar.
Yes, my lord. 2023, 10 SCC 531, my lord.
Uh-huh. Correct. Yes.
I could put my submissions, Your Lordship.
Anything you want to add?
No, only this, my lord. In item 12, my lord, I have found the reason for our days to, as written 433, my lord. Because at first, this item number 13 is, there is a delay of 43 days, my lord. This is the first we have received. And since all the grounds are the same, my lord, there's a certain copy paste. And in item number 12, it should be 4 to 7 days, not 3 days, my lord. That is only what I like to add. We have made an inadvertent mistake, my lord.
Okay.
That is all, my lord.
All right. Let's go.
Item number 14 and 15.
Yes.
Yes, my lord.
And hopefully if we can pass judgment in open court. Next matter. We take these files first.
Okay.
Clear these files first. Keep the books here only.
Item 14 and 15. May it please your lordship, by this application I have sought for an implement in the connected WPC number 128 of 2025. Implement to be implemented as the respondent, my lord. Yes, to be an intervener, my lord. Because what happened is that the 3G award has been made by the Kala Aizol, reflecting the wrong name of the landowner. I am the landowner whose land is to be affected by the construction of the highway. whereas my neighbor has been, name has been reflected in the 3G award passed by the Kala. And I have submitted a complaint to the Kala, and export verification has also been conducted, my lord, wherein this is second time, my lord. First order, they've prayed for filing objection.
May I please your lordship, the leading counsel for the respondent number 1, Mr. Benjamin, was on leave. So if this matter may kindly be taken up after 2 weeks. Yes, my lord. Yes, my lord. His leave note was also been displayed in the cause list. Benjamin Lalsamona, number 4. Yes, my lord. Sir, my lord. My lord, I do not have any knowledge about.
My lord, they've accepted notice on the last court date, that is 12/12/2025. Yes, my lord. It's just for an implement, yes, my lord. Let them file. No, the main writ petition may be kept in abeyance till then, my lord. Because
Same subject matter.
we're seeking for implement. No, in the main petition.
Well, it's only in relation to the main writ petition. Your lordships are not audible.
Admission item 1. My lord, if may please, regarding item number 14 and 15, that's my senior on virtually who's appearing virtually. If his voice is not audible, I want to intervene. My lord, item number 14 and 15, the respondents are NHIDCL. In the main item 15, it's respondent number 7 to 10. My lords, we have received the instruction yesterday night to appear on behalf of NHIDCL. So, my lord, may please, we will file the wakalatnama and submit the counter affidavit. And by mistake, my lords, the respondent in the cause list has been, the advocate's name has been, by mistake, has been mentioned in the cause list. Item number 14 and 15. Item number 14 from 8 to 11 and item number 15, 7 to 10. We are appearing on behalf of NHIDCL and the advocate name has been mentioned by mistake. My lord, Karthik Jain. Yes, my lord. Shubham Palewal. Yes, my lord.
Yes.
All right. Karthik Jain and Shubham Palewal, I'll give it in writing also. All right.
I'll have to seek instructions.
Either way, my lord, they'll be appearing. They'll be appearing on behalf of the NHIDCL, not Samuel, as per his instruction. He just submitted before the court right now, my lord, just now.
Yes, my lord. I have not been instructed not to appear, my lord. So I'll have to ask for instruction whether I am to recuse myself or not in this matter.
My lord, same thing in item number 15 for respondent number 7 to 10. Yes, my lord. My lord, there is no wakalatnama on record. We'll be filing within this week the wakalatnama. And we have received the instruction from NHIDCL to appear in this matter. My lord, he has accepted the notice and received the copy of the service also. It's by mistake the name has been appearing, but no wakalatnama has been filed. Lal Zakima. He has accepted a notice on behalf of NHIDCL. Maybe on that prerogative, the name of the advocate has been appearing as respondent number 7 to 10. Usually, sir, he's a standing counsel for NHIDCL, but this particular matter we have been appearing. We will be appearing. Shubham Palipal. Obliged, my lord.
My lord, I would like to seek your lordship indulgence, although it is not the time for mentioning item. My lord, item number 4, as my learned council friend is standing here. This matter is just for fixing date for admission hearing, my lord. We want it to be fixed on next Thursday, 5th.
I have no objection.
5th February, my lord. And in the meantime, my lord, I may be permitted to. Yes, my lord. Before that, my lord, I may be permitted to file a short reply, and the same will be filed by Tuesday, 2nd February. Reply, yes, my lord. Additional affidavit, sort of. I was granted time to file additional affidavit before, and the same was replied by the counsel for the petitioner. And again, my lord, my MZU, my respondents wants to file a reply to that affidavit.
Additional affidavit in the middle.
Additional affidavit, my lord. Yes, my lord. My junior has submitted that we are not filing any affidavit. But thereafter, my lord, we have received comments from the MZU. That is why we pray your lordship to grant us to file a short reply, my lord. That may not be necessary. No, in fact, my lord, just to satisfy the clients, the MZU, we want to file this additional affidavit.
Normally, writ petition is filed, counter affidavit is filed, thereafter petitioner gets to file a rejoinder affidavit.
Right.
Now, in certain exceptional circumstance, when there's some requirement to file a particular affidavit, then court may grant you that liberty.
True, my lord.
Otherwise, normally after rejoinder affidavit, the matter ends there.
That
Otherwise,
is
it
true.
go on and on.
I have tried to make them understand this fact, but they insisted that I should file additional affidavit on this basis, my lord.
Please write. Next line, although on the last court date, it was submitted that the respondent numbers 1 to 3 will not be filing any further affidavit. But today, Mr. L.H. Dhyamsharma, Learned Senior Counsel, representing respondent numbers 1 to 3, submits that as he has received some instructions lately, he may be permitted to file an additional counter affidavit. Considering the prayer, let such affidavit be filed on or before. On or before? 3rd
Third, yes, my lord.
3rd of February 2026, with a copy to the other side. Well in advance. List accordingly.
Obliged.
Item 4. See, in the second half at 2 o'clock, there's one matter which has to be looked into. And after that, perhaps we'll sit again, if so required.
Yes, there are certain items still left.
My lord, one more thing. Tomorrow I'm having some personal difficulties. I may not be able to appear before your lordship. I'm having one fixed item. So my junior will be here and mention about this.
Surely, surely. That somebody be there.
My lord.
So we'll reassemble at 2:15 for the today's cost list.
Today's call.
2 o'clock to 2:15, I have some matter which will be attended by only the council's consent,
Okay.
not by
All.
all.
My lord.
All right?
Admission, item 1.
May it please your lordship, I'm appearing on behalf of the state respondents in this matter. Your lordship, as per the, this matter has been listed for admission hearing. However, your lordship, as per the court order dated 5/9/2025, initially the concerned file was misplaced in the Advocate General's office, your lordship. And upon receiving of the extra copies from the Under Secretary PWD, your lordship, the affidavit has also been submitted by the PWD in 2021 itself. However, your lordship, if I may be granted at least 2 days' time to further gather additional instructions, and if the matter may be listed again after in the next week, your lordship.
No, you misplaced your file that was submitted in September 5th last year.
Yes, your lordship, and then
You have not yet traced out the file.
yes, your lordship, it had been we had to get a the Xerox copy from the Under Secretary PWD, your lordship. I had received it in the month sometime in the month of November, your lordship, and then after which, your lordship, it was listed again for admission hearing. However, your lordship, upon perusal of the affidavit submitted by the state, if I may be allowed to at least be granted at least 1 week time to go through the instructions, further instructions that I have sought.
Further instructions for what?
Your lordship, this matter pertains to Serkan Baga case, land acquisition.
Maybe, but pleadings are not complete till now.
Your lordship, it is complete. However,
Then
your lordship, the
What further instructions you want to seek? Please clarify.
that is, your lordship, there is an appeal which is also pending regarding the same award.
Where?
Your lordship, before this.
No, Your Lordship, the thing is that I have submitted WA judgment passed by this Honorable Court, wherein award number 3 of 2014, Serkan to Baga Road, which was allowed by this Honorable Court single bench, and the state appealed the same, and wherein this Honorable Court passed that since there's one WPC 167 of 2018 was there, whereby they have complied with, and this WPC 167 is not challenged or dispute in the WA. That's why it's closed. WA was closed. So this judgment is awaited by this case. The outcome of the judgment you are waiting, and since the judgment, WA judgment is out, in my opinion, here I prayed to pay my compensation in accordance with draft award number 3 of 2014. This is the case. So it cannot be appeal, since the appeal is already disposed by this Honorable Court.
Appeal was against which order?
Single order, in the single order, award number 3 of 2014 was challenged. The thing is that the law department saying that the award is to be cancelled by alleging that it's a lapse, wherein the claimants challenged that order, and the single bench allowed the challenge, and that single order was challenged by the state.
Then what
By
happened to the
filing
appeal?
WA. Yeah, I have submitted the copy of WA also. Your
What
Lordship.
happened to the appeal? Was it allowed or dismissed?
Here it's in view of the reasons stated above, the observation of, not this one, Your Lordship.
No, you just tell me the result
Yeah.
of the
The
appeal.
result is not even set aside WA, I mean single bench order. It says that
Read appeal number.
written appeal number 1 of 2023, Your Lordship. From the para 2014, Your Lordship. At any rate, the direct pass in WPC number by order dated has been acted upon, and that the same has not been questioned nor challenged by anyone, including the present respondent. In view of such development, the challenge made in writ appeal has only been rendered redundant, if not infructuous. The respondents have raised the issue of the steps taken by the authority to be not in terms of direction passed in WPC number 167, 2017. However, the same, in our considered view, cannot be a subject to issue to be gone into the present writ appeal. In other words, the scope of the instant writ appeal in our considered view cannot be enlarged by taking into account what had transpired in respect of the issue raised in another writ petition, and whether the same was decided in an appropriate manner or not. Therefore, taking into account the specific issue raised in the writ appeal and the challenge made to the direction of the learned single judge, and further taking into account the subsequent development that have taken place, we find that nothing is left in the writ appeal to be examined. Accordingly, the writ appeal is dismissed. It is, however, observed that the dismissal of the writ appeal would not mean that the respondent or any of the genuine landowners are debarred from asserting their rights and claims, which, however, should be in accordance with and as may be permissible in law. As we have come to the above conclusion, there will be no requirement to dwell upon the authorities relied upon the parties. This is the order. So in the present petition, Your Lordship, you have dispute order WPC number 167, 2017 order. This is the way they complied is wrong. So this is the petition. Since we are genuine owner, award number 3 of 2014 is still there. And after this WPC number 167 of 2017, our award was reduced. That is the case. So after passing this order, in my understanding, this petition can be examined, since this judgment says that you can claim if we dispute 167 of 2017, the way they comply. So we are disputing the thing.
You're praying for the disbursement of the award,
Yes.
the draft award. Money has
On
been
protest, we pay this honorable court to receive the award assessment made, fresh assessment made in award number 3 of 2014. So this honorable court allow us to receive the same on protest. And we pray this honorable court in this petition that draft award number 3 of 2014, you have awarded kindly see, Your Lordship, my petition, read petition number 37 of 2019, para 9.
No, I'm looking at a prayer of your writ petition.
Yes.
It says that you're praying for disbursement of the award.
In
Draft award,
Yes.
number 3 of 2014.
Yes.
Why has it not been disbursed?
The thing is that, Your Lordship, it disbursed a fresh assessment, not from the award number 4 of 3 of 2014. Here it says that
Okay, after this draft award 3 of 2014, there was a fresh assessment.
assessment,
So what was disbursed is from the fresh assessment,
fresh assessment,
not from the earlier one.
not from the earlier one.
What
Here
do,
the
they, what do they
difference-
say? What do they say, the other side?
Nothing after passing this
No,
judgment.
in the counter affidavit, what do
In
they
the
say?
saying that this honorable court said that wait for the result of WA, and
Who are the parties here? Government.
Government only.
Apart from government, who else?
No one.
Who is supposed to pay you the compensation?
PWD government,
PWD.
state.
You see. So, Ms. Nalan Louis, then what do you want? What
Yes,
instructions
Your
do you want?
Lordship. I had received just a soft copy of a additional fund. So, Your Lordship, this is dated 21 September 2018, and it is not annexed in the affidavit that was filed in 2021. So, in that regard, Your Lordship, I may be given time to at least confirm with the state respondents as to whether this revised award may be included or not in, or is it relevant at all for this current petition, Your Lordship.
That clarification only. Get it by tomorrow.
Yes, Your Lordship.
We'll have it on Friday.
Yes, Your Lordship.
Release the matter again on Friday to enable Ms. Nalan Louis, learned government advocate, to obtain instructions.
Much obliged, Your Lordship.
Next.
Item 2.
My lord, despite the opportunities granted earlier for filing the rejoinder affidavit, we cannot file it yet because the clients are trying to engage senior counsel, and the senior counsel will have to do the drafting. So if
Senior counsel don't do draftings. These are the junior counsels who do the drafting. Senior counsels, they settle the draft. That is the procedure everywhere. Mizoram is not an exception.
anyway, my lord, they are trying to engage the senior counsel, so we'll
You
have
can
to
engage
wait.
the senior counsel to argue.
Yes, my
You
lord.
will show him the draft, he'll settle it, and then you can file it.
Yes, my lord. So please.
So you need some more time.
yes,
How much
my
time?
lord. 2 weeks, my lord.
Counsel for the petitioners expresses some difficulty to conduct the case today since the rejoinder affidavit could not be filed. To stop, it is submitted that the petitioners are contemplating to engage the senior counsel in the matter. And that they require 2 weeks' time to file the rejoinder affidavit. In view of above, and as paid for, list the matter again after 2 weeks on a date to be fixed by the registry.
Obliged, my lord.
Item 3.
Your Lordship, I'm appearing on behalf of Mr. B. Laram Enga, counsel for the petitioners. If Your Lordship may kindly grant us further 2 weeks' time to file a rejoinder against the affidavit in the opposition filed by respondent number 4.
Okay, as paid for, further 2 weeks' time is granted to the petitioner to file affidavit in reply to the affidavit in opposition filed by respondent number 4.
Obliged, Your Lordship.
List again after 2 weeks.
Item 5.
My lord, in item 5, I am for respondent number 6. My drafted affidavit is not yet returned for filing, my lord. I may be granted 3 weeks' time.
When did you send the draft?
I sent in the month of December, late December.
So why do you require 3 weeks' time? It must be on the way.
It may be, my lord. No, 2 weeks may be given, my lord.
Ms. Zainab Sangpi, London CGC, appearing for the respondent, Union of India, submits that the draft affidavit of the respondent Union of India was sent for vetting in the month of December. And therefore, she prays that she may be given further 2 weeks' time to file the same. As the same is awaited till date. In view of above, list the matter again after 2 weeks.
Obliged.
Mr. Samuel, you're there for?
The state respondents, we have already filed, Madam.
Okay, Mr. Samuel Banuti Sangte, learned additional AG appears for the state and submits that counter affidavit is already filed by the state.
Lordship, I'm appearing on behalf of my senior. We'll be filing our affidavit in reply to state respondents.
How much? 2 weeks?
2 weeks.
Your good name?
Stephen Lalbuatsaya.
Mr. Stephen Lal Botsaya appears for the petitioners. Petitioner?
Yes.
Only one petitioner, isn't it?
Yes, only one.
Stop. Liberty is also granted to the petitioner to file reply affidavit to the affidavit in possession of the state respondents by the next date. Yes.
Obliged.
Item 6.
My lord, similar prayer.
What about 5? Over this side. Similar prayer?
Yes.
Okay, as prayed for by Ms. Zaram Sampul and CGC. Further 2 weeks' time is granted for filing with counter affidavit of the respondent Union of India. List again after 2 weeks.
Obliged.
Item 7.
Your Lordship, I seek your indulgence. I may be given further 2 weeks' time to file reply affidavit filed by the respondent number 4 and 5. I
Okay,
have
yes.
filed 1, 2, 3
As
reply
prayed for
affidavit.
by Mrs. Dinariti Azul, learned counsel for the petitioners. 2 weeks' time is granted for filing rejoinder affidavit to the affidavit position filed by respondent numbers
4 and 5.
4 and 5.
Your Lordship, interim pass earlier may be
List
continued.
again after 2 weeks. Stop interim order passed earlier shall continue to the next date.
Item 8.
Yes, Your Lordship. I'm representing the state respondent 3, 4, and 5. And Your Lordship, on instruction, the state do not propose to file an affidavit. I already filed my lord.
Okay. Mr. Stephen Lalbotse, learned counsel appears for the petitioners. So, Ms. Vanesiami, learned government advocate, appearing for the state respondents, submits that the state respondents will not be filing their counter affidavit. So, Ms. Zarim Sankui, learned CGC, appearing for the respondent, Union of India, submits that affidavit has already been filed by the Union of India. Stop in view of above, place this matter for admission hearing after 2 weeks.
Lordship, in the meantime, we would like to file
Petitioners
affidavit
may
reply.
file rejoinder affidavit to the affidavit of opposition filed by the respondent Union of India. In the meantime, if so advised.
Obliged.
Item 9.
Yes, may please your lordship, I move for the petitioners and my lord, the AD card in respect of respondent number 426 have not yet returned. And may I request that this matter may be listed again after 2 weeks to await completion of service, my lord.
Office note dated 27/1/2026 indicates that service report is awaited from respondent numbers 4 to 6. So Ms. Man Lomsangi,
Rosie.
Rosie Man Lomsangi, learned counsel appears for the petitioners, while Mr.
Arnal Munsiyama.
Arnold Hunsiyama, learned counsel appears for respondent numbers 1 to 3.
And my lord, the interim order passed earlier shall continue, my lord.
Next para. We'll have it after a week.
Okay, fine. Yes, my
It's
lord.
the matter again after a week. And in the meantime, the registry shall track the postal consignment sent to track the postal consignment of the notice sent to respondent numbers 4 to 6 and put up a note. Stop interim order passed earlier shall continue till the next date of listing. Yes.
Deeply obliged.
Item 10.
Lordship, in this case, notice was issued on 16/10/2025.
And Your Lordship, this is the second time it is listed, and I'm seeking another 2 weeks' time to file my affidavit.
You appear for all the respondents?
Sole respondent, Your Lordship, 1 to 5.
I speak for Ms. Vanessiami, London Government Advocate, appearing for the state respondents. We cancel the order. Mrs. Dinariti Azul, Learned Counsel, appears for the petitioner. Stop. Ms. Vanessiami, Learned Government Advocate, appears for all the respondents and prays for further 3 weeks' time to file counter affidavit. Praise allowed. It's the
Oblige.
matter again after 3 weeks.
Oblige.
Part 2, item 9.
Yes, what is this matter?
Lordship, this is a DRDA staff who were of job in the government service in pursuance to the judgment and order passed by this honorable court. However, the way they of job is against the judgment and order passed by this honorable court. Earlier, our senior who had filed a writ petition that is in Your Lordship, kindly see page number 62. And I'll read the operative portion that is in page number 110.
Whose case is this?
Uh,
Page 62?
Page 62 is our senior case.
Okay.
Our writ petition was disposed in accordance with this
This order.
judgment. Para 9. From Para 9, I'll read, Your Lordship. DRDA is a society registered under the Society Act for implementation of poverty alleviation program taken up by the central government from time to time. The society has been in existence since 1993, and it does not look like it would be done away with in the near future, keeping in view the county's long-drawn war against poverty, especially in the rural areas. Therefore, certainly the service of the petitioners will continue to be needed for implementation of
You are reading from which
Para
paragraph?
9, page 110. That's it.
But you showed me page 62. This is 82, I think.
110. Para 9. The judgment is start from page 82.
82.
Yeah.
Yes.
However, the operative
I heard
portion.
62, that's why.
Yes.
Yes, then?
DRDA is society registered under the
No,
society.
you read from where you stopped.
Yes, Your Lordship. The fact that the petitions have been allowed to continue in their respective posts shows that their service have continually been utilized and will continue to be used in future too. In fact, the state respondent have not stated in their affidavit that their services are no longer required or are not going to be required in the near future. Therefore, there is no gain in saying that they are contract employees and they can be removed anytime. In fact, ours is a welfare state, and the government is of the people, by the people, and for the people. Therefore, to say that employees, in whatever status they may be, are at the mercy of the state would be against the very indeed philosophy and principle on which our policy is founded. It is clear from the letters of the central government and the guidelines of DRDA that the central government is willing to share the burden of pay and allowances of DRDA staff at the ratio of 90:10 basis. From this, it is also clear that what the state government would or should do is absorb the DRDA staff in line departments and place them on deputation in DRDA, where their pay and allowances at the ratio of 19:10 basis shall be shared by the central government and state government. It is an opportunity for the state government to give employment to people of the state by contributing only 10% to their pay and allowances. Therefore, the state government should verify the dates of appointments of the petitioners and take appropriate action for absorption of those petitioners who were appointed during or before year 2008. That is when the new guidelines was issued or not notified. It may be mentioned here that in the case of similar situated person, appropriate action have been taken by the state government as per the order of this court as mentioned above. Therefore, there is no reason why the same action should not be taken in the case of the writ petitioners. Accordingly, the respondents are hereby directed to complete the process of absorbing of petitioners who are entitled to be absorbed in terms of what has been stated above within a period of 3 months. Accordingly, this writ petition stands disposed of.
Okay.
And
Pursuant to that, Annexure 10 was passed. Office memorandum,
yes, Your Lordship, annexure,
page 122.
yes.
And you are aggrieved by paragraph 11 at page 123.
Your Lordship, here, annexure 10 is our, this is annexure 6, and our judgment is,
No, I want to know your grievance.
yes, my grievance is that,
Come to page 123,
123,
paragraph 11.
yes.
All employees absorbed under this scheme will be treated as new employees.
Yeah, they treated
one.
as new employees, yes.
This is what you're challenging.
Yeah, we are challenging,
You're challenging the OM insofar as paragraph 11 is concerned.
yes. And
Then what else?
I have challenged annexure 15 also, whereby the minutes of the cabinet meeting
Page?
page. Lordship, prayer portion, I'll come from the, first, I have impugned annexure 10 scheme, para 11, and next, impugned agenda 10.4 of the meeting minutes, that is annexure 12. Annexure 12 is page number 130. 10.4.
Which agenda?
Agenda, minutes of meeting of the Council of Ministers
Which particular agenda?
regarding the objection of our
I think it's
service.
paragraph 10.
10.4. Pay protection provision may be made in terms of cross emoluments received.
What does it mean?
That means, Your Lordship, not protected the last pay of the immediately before absorption, the last pay was not protected, but only the cross emolument. Cross emolument is including basic pay, house rent, DA. So only that emolument is protected. So we are aggrieved by that.
No, pay protection provision may be made in terms of gross emoluments received.
Yes, gross only. Usually, the pay protection is made in accordance with the pay received immediately before absorption.
Right, so how does it bar you here to receive that?
I think is that,
You have the net pay and you have gross emoluments.
yeah,
Net emoluments and gross emoluments.
basic pay and HRA, DA, etc.
That is included in the gross emoluments.
Gross emolument.
So it's, your pay is protected.
No.
How do you say it's not protected?
The pay protection is made that immediately before absorption, we are in 7 pay. So including the HRA, DA also more than the emolument, because last pay, if you protected pay protection is made, it should be from the last pay, immediately before the absorption. I'll come to the lordship will understand that I have made a chart here.
See, this will take some time, isn't it? Today, I have to rise before
Yes.
3.
Tomorrow.
I have to rise before 3.
Yes.
You come prepared tomorrow? Please write, list this matter again tomorrow in the admission column.
我手头一个